If the account had been owned by a revocable living trust, the outcome would have been completely different. Two children could have received their shares outright, with the special needs grandchild's share held in a discretionary trust without any loss of benefits, without court involvement, and without any government payback requirement. The same money, the same family, radically different results, all because we wanted to use a duct tape solution. Pay on death and transfer on death beneficiary designations aren't inherently bad. In fact, they're often marketed as quick, clean ways to just keep assets out of probate. And in some limited situations, they're doing exactly that. The problem is that beneficiary designations are a one note instrument. They answer only one question: who gets the money? They don't account for age, timing, taxes, disability, blended families, or what happens when life unfolds in ways that no one expects. That's where revocable living trusts and other properly designed trusts matter. They don't just name recipients, they anticipate problems, give instructions, and adapt when circumstances change. Simply slapping names on forms can feel efficient and certainly simple, but it often creates outcomes that the person never intended. Here are three situations where that duct tape approach fell apart. Probate attorneys don't benefit when people truly understand probate and try to avoid it. Probate attorneys profit when people use wills instead of trusts. If you weren't told the benefits of avoiding probate, then leave a comment and like and subscribe if you want more of this information explained in plain English. A father tried to protect his sons and accidentally gave control to the court. So, a divorced father died suddenly in an accident. He had two young sons, 7 and 9 years old, and a $1 million life insurance policy. Wanting to avoid probate, he named both sons directly as beneficiaries. His life insurance agent assured him this is the simplest solution and it's going to avoid probate. What the agent didn't explain was what happens when minor children inherit large sums of money outright. The father had done some planning. His will clearly stated that any inheritance for his children should be held in trust until they turn age 30, unless the trustee chose to distribute it earlier. He named his brother to manage the money with his sister as backup, again, in his will. And on paper, it looked thoughtful and responsible. But the will only controlled assets that went through probate. The life insurance avoided probate. Because the boys were under 18, the insurance proceeds couldn't simply be paid to them. Instead, two separate guardianship estates had to be opened through the probate court. And because guardianship appointments are governed by statute and not by the will, the three children's mother, the father's ex wife, was appointed to manage both of those inheritances. The result: each child will receive their share outright at age 18, not 30, not under the brother's supervision, 12 years earlier than the father intended. Even worse, the life insurance proceeds ended up under court supervision anyway. The probate process he was trying to avoid became unavoidable, just in a different, more restrictive form. Had the life insurance paid into a revocable living trust instead, none of this would have happened. The brother would have served as trustee, the age restrictions would have been honored, and the court would never have to have been involved. The beneficiary designation didn't simplify things, it stripped away all the safeguards. Second story, there was a 6-day gap. It rewrote an entire inheritance plan. In another case, a married couple, both in second marriages, owned separate annuities. They had no children together. Each spouse named the other as the primary beneficiary and their own children as contingent beneficiaries, and it seemed fair, balanced, and straightforward. Then they were in a serious car accident. The husband died first. The wife survived him by 6 days before passing away herself. That small gap in time triggered a problem no one had noticed. The annuity's survivorship clause required only 3 days. Because the wife outlived the husband by more than 3 days, the annuity company refused to pay the husband's annuity to his children. Instead, it insisted that the funds be paid into the wife's probate estate. That single technicality meant the husband's children were effectively disinherited, while the wife's children end up receiving both annuities. And because the annuities held tax deferred retirement funds, routing the money through probate created a second problem: significantly higher income taxes that could have been spread out, but now it couldn't be. This wasn't a family conflict, it wasn't misconduct, it was paperwork doing exactly what it was saying it was going to do without anyone appreciating the consequences. With proper trust based planning, the outcome would have matched the intent. Each side's children would have received what was meant for them, and the tax impact could have been managed over time instead of all at once. The beneficiary forms didn't fail, they just weren't designed to handle this scenario. And now the third story: equally per stirpes became a benefits nightmare. In the third case, a widow owned a stock account worth over $1 million. She named her three children as pay on death beneficiaries, quote, equally per stirpes. On its face, that sounds responsible and even sophisticated, but one of her children had already passed away by the time she did, leaving behind an adult child with special needs, the grandchild. Because the account passed by beneficiary designation, that grandchild received their parents' share outright. And with it, they lost all eligibility for Medicaid and other public benefits almost immediately. The family now has only one option to undo the damage, which is to petition the court to create something called a D4A special needs trust. That may preserve benefits, but it comes with big strings attached. The trust will be tightly regulated, distributions will be limited, and when the beneficiary dies, the government must be paid back from whatever remains. All of that complexity exists because the money was received outright first. If the account had been owned by a revocable living trust, the outcome would have been completely different. Two children could have received their shares outright, with the special needs grandchild's share held in a discretionary trust without any loss of benefits, without court involvement, and without any government payback requirement. The same money, the same family, radically different results, all because we wanted to use a duct tape solution. Beneficiary designations don't plan, they just transfer. These stories have a common thread. In each one, the person was trying to be efficient and trying to be simple. And in each one, the beneficiary designation technically worked. And in each one, it produced a result that the person never wanted. Beneficiary forms can't transfer assets, they plan for lives. If your plan needs to handle minors, blended families, potential disability, taxes, or timing, relying solely on a pay on death or transfer on death designations alone is a big gamble. It's not a strategy. If you want a clear, plain English explanation of how revocable living trusts work and why they protect families far better than just beneficiary forms, you can start with the free information at freetrustcourse.com. Again, that's freetrustcourse.com. It's designed to help you see where duct tape planning breaks down and how to avoid learning these lessons the hard way. And as I always tell my clients, please stay safe, plan ahead, and enjoy life. And whatever you do, make it a great day.